I'm very happy to be invited to speak about climate litigation, especially for a project that I think is so necessary and inspiring, and a project that seeks to put this question of, climate justice in a very diverse, context that brings together persons from different fields of practice and, multidisciplinary actors, because I think the climate crisis affects everyone, but it particularly affects small island developing states, such as those in the Caribbean. I think the solutions to the climate crisis cannot come from the venues that are now, the dominant venues controlling climate discourse. I think the solutions to climate crisis will come from, ordinary people, the people on the front lines of the climate crisis, Indigenous and Afro-descendant people, and so on. And so this effort to bring together diverse voices, I think it's very important. So I'm just going to share my screen. Okay. Okay. So as Ardeen mentioned, I'm Malene Alleyne. I'm a human rights lawyer by training, but I don't like to refer to myself as a human rights lawyer. I'm just someone who happens to know a little bit about the law, and I use the law in a transformative way, seeking to address legacies of colonialism and enslavement. And of course, when we talk about those legacies, we have to talk about the climate crisis. And so the question for me is always, how can the law be used in a way that not only addresses, like the symptoms of the climate crisis in terms of human rights impacts, but also the underlying structures that cement the climate crisis in this current imaginary, which I argue is a colonial imaginary. How can we use the law, which has traditionally been complicit in enforcing, reinforcing, and maintaining the very structures that are at the root cause of the climate crisis? How can we build on it and use it in a more transformative way to bring really meaningful justice? And so as I give my presentation, which is on climate litigation, I want us to keep those questions that, at the front of our minds, because even as I present on climate litigation as a tool for climate justice, the question that we all have to ask is, what are the limitations of climate litigation in bringing about climate justice in a more, broad sense in terms of undoing harmful structures and legacies that are the root cause of the climate crisis, and also repairing historical power imbalances that make something like the climate crisis a reality for the Caribbean. So with that introduction, I'm not sure the details of what you've discussed before, but I'm going to assume that you have some knowledge of just climate lingo like loss and damage mitigation, adaptation. I'm going to assume that you've dealt somewhat with the impacts of climate crisis in terms of catastrophic weather events, slow onset disasters like droughts, rising sea levels, and so on. Okay.
Yes, we covered a bit of those yesterday.
Perfect. And so in my presentation today, I have about 20 minutes, and I will talk about three things. First, I want to look at the role of climate litigation in advancing climate justice. Because at the end of the day, if justice isn't at the end of the road, then we have to rethink our methodologies and our approaches. The second thing I want to do is give a quick overview of trends in climate litigation, keeping the Caribbean in mind, but noting also that at this moment in time, climate litigation in the Caribbean and the so-called global South generally, as of right now, forms a small fraction of global climate litigation. But I would say that the trend is that there is an increasing effort to use climate litigation in the Caribbean and to see how it can be used in a transformative sense in terms of delivering climate justice to the Caribbean. And then the last thing I will look at is, the challenges and opportunities that climate litigation presents for the Caribbean. And as I said in the introduction, I think that discussion is extremely important especially because climate litigation is expensive. So if it's not going to deliver the justice goals of a particular community, I think that discussion is important. Okay, so my discussion is based a lot on this Global Climate Litigation Report from 2023, which for me is perhaps one of the most important pieces of writing from the point of view of the United Nations. It was done in collaboration with the Columbia Law School. Important pieces of writing in terms of understanding what climate litigation is, what climate litigation has been doing, and what the opportunities are in terms of where climate litigation can go in the future, including the Caribbean, which is like a blue ocean for climate litigation. And, you know, when we talk about litigation, we always have to talk about what is the problem that we're trying to solve. What is the legal issue, or what is the problem that we're trying to solve by way of going to adjudicatory mechanisms, courts and so on, to try to get a decision to remedy something. And so, I looked through this Global Climate Litigation Report, and the way they framed the problem, for example, is that to keep the long-term temperature goals set out in Article 2 of the Paris Agreement and limit global temperature rise to 1.5, countries need to significantly cut global emissions in half by the end of this decade. And so this is one of the most dominant framings of this issue of the climate crisis. It's this rising temperatures and the need to cut greenhouse gas emissions that are fueling the climate crisis, and the need for states to take, more ambitious targets, take on more ambitious targets to cut greenhouse gas emissions, and even, stop certain extractive activities that are fueling the climate crisis. And so I want to pause here and ask the first question to the audience. I don't know if you'll have time for kind of back and forth discussion. The first question is, what do you think about this problematizing of the issue that is, focused on this issue of temperature rise? Is that the only problem, or is the problem, something deeper? Are we looking at the symptoms of the climate crisis, which is greenhouse gas emissions, rising temperatures, and then the impacts in terms of catastrophic hurricanes and rising sea levels? Are we looking at the symptoms here? Or are there, more structural issues at play? But this, this comes from the Global Climate Litigation Report. And I think it's framed this way because when you look at climate litigation, a lot of it is focused on this, this temperature threshold approach to the climate crisis. So that's the problem. And so under the first bucket of, things I'll discuss in terms of the role of litigation, if that's the problem, as set out in the Global Climate Litigation Report, then the role of litigation or climate litigation, and this is what the Global Climate Litigation Report says, is that it provides civil society and individuals and others with one possible avenue to address inadequate responses by governments and the private sector to the climate crisis. In climate cases, plaintiffs seek to compel more ambitious mitigation and adaptation goals from the public and private sectors. Now, I want to pause here again and interrogate this, because I don't know how much detail you went into the Paris Agreement, but the Paris Agreement, which is, the overarching framework in terms of how we think about state obligations in terms of the climate crisis, the Paris Agreement sets out a number of obligations. The Paris Agreement talks about mitigation, which is this idea of mitigating the impacts of climate change and communicating and maintaining nationally determined contributions and overall reducing greenhouse gas emissions. So Article 4 of the Paris Agreement talks about that, and we see this in climate cases here. Climate cases seek to compel more ambitious mitigation. The second aspect of the Paris Agreement is adaptation, and this is the idea that, we want to enhance the adaptive capacity and strengthen resilience and reduce vulnerability to climate change. And this is in Article 7 of the Paris Agreement. And so what climate litigation is seeking to do, according to, the Global Climate Litigation Report and the dominant litigation that's going forward, is to compel more ambitious adaptation goals. Okay. But is anyone familiar with Article 8 of the Paris Agreement? And can we make this a little interactive so I can hear someone from the audience just to gauge if we're on the same page? Article 8 deals with loss and damage. And so is there anyone who has heard about this concept of loss and damage?
No.
Okay.
Not until this point. So
Not
this is new. This is new stuff, so it's very interesting. Yeah.
Perfect. Okay. So we spoke about mitigation, which is the idea that you want to mitigate the impacts, reduce greenhouse gas emissions. We spoke about adaptation, which means you need to take efforts to adapt to the climate change and strengthen resilience. And this is what's, put in the climate litigation report about what litigation hopes to compel governments and private actors to do. But there's this other article in the Paris Agreement about loss and damage. What if you can't mitigate the effects? What if the effects are so catastrophic that, you can't adapt? Mitigation is not working. What if you can't, the damage is so catastrophic that you call it loss and damage, Article 8 of the Paris Agreement says, it recognizes the importance of averting, minimizing, and addressing loss and damage associated with the adverse effects of climate change, including extreme weather events and slow onset disasters, and the role of sustainable development in reducing the risk of loss and damage. But, as I said, this idea of loss and damage is as the word suggests, loss and damage. And, if you read the scientific reports on the climate crisis, you will see that loss and damage includes non-economic loss and damage, such as damage to culture, These are things that are so, I'm just thinking about it so profound, like when indigenous people, their ancestral lands are, threatened or destroyed because of the climate crisis. We've moved beyond mitigation and adaptation. Right now, we are dealing with a level of loss that is so catastrophic. Like, how do we repair that? And I bring up this concept of loss and damage, and particularly non-economic loss and damage, because in this very extensive global climate litigation report talking about climate litigation, we see that most of the cases are about mitigation. Some of them are about adaptation. But where is the loss and damage? Where is the loss and damage? And if you even read the Paris Agreement, when it comes to mitigation, we talk about, binding commitments by all parties to mitigate. When we talk about adaptation, we talk about what states have to do to strengthen adaptive capacity. But when we get to loss and damage, the language is something like, oh, yes, the agreement recognizes it's important to address and minimize loss and damage. But that clause doesn't really have the teeth necessary to seek accountability generally, and certainly not within the litigation context. So that's another point I want you to think about in terms of climate litigation. And so going forward, the climate litigation cases that we talk about are going to focus on mitigating, reducing greenhouse gas emissions and adapting, which are extremely important. But, I go back to my first question, how can we get more transformative change in terms of addressing the underlying structures and systems that are at the root cause of the climate crisis, and then repairing the nations and peoples who are most vulnerable to the climate crisis, repairing them in a very broad sense of the word, reparations. Okay. So with that in mind, I just wanted to offer you a definition of climate change litigation, and how the dominant literature has sought to categorize it and understand it and capture it. And it is defined as including cases that raise material issues of law or fact relating to climate change, mitigation, adaptation, or the science of climate change. And so that is the understanding that, dominant discourse has in terms of what climate litigation is. And sometimes when you define a thing, it kind of indicates what you hope the thing will do. And so that's the thinking around climate litigation. I just found this graphic, very interesting. It shows you where all of the climate litigation cases are around the world. You will see that this big piece of the pie is, represents cases from the United States, 70%. This is as at December 2022. And then another section of the pie is like for the rest of the world. We have a lot from Europe, which is significant because, a lot of our constitutions across the Commonwealth Caribbean are based on the European model. And so at least in Jamaica, I found that courts are very interested in looking to the jurisprudence of European authorities in terms of understanding the obligations that arise under our constitution. And so you can see the cases, as I said, the so-called global south or developing world has a very small percentage, but they do pick up this, as at 2022, they do pick up 3 cases in Guyana dealing with the issues related to climate change. And my understanding is that one of those cases, for example, that argues that about the impact on the right to a healthy environment in the context of ExxonMobil's fossil fuels industry that was launched recently, well, fairly recently in Guyana. The argument is that, there's a violation of the right to a healthy environment. And on that note, I would say that Guyana is one of only 2 countries in the Caribbean that recognizes the right to a healthy environment. Jamaica is the other country. And so what happens in Guyana in terms of this climate litigation is important because they have this right to a healthy environment that they can use. I see that I'm frozen, so I'm just going to stop my video and start it again. Okay, perfect. And so now that we've spoken about the role of climate litigation, which, as I said, is really trying to get states, to comply with their mitigation and adaptation responsibilities, to, reduce greenhouse gas emissions and to enhance the adaptive capacity of its citizens, of its, countries. The main categories of climate litigation cases so far can be summarized as you see on your screen. The first is the use of climate rights in climate litigation. And because I'm a human rights lawyer, this is the most interesting to me because, what these climate rights or rights-based climate litigation cases are doing is they are leveraging the body of human rights law as set out in the national constitution or at the international level, in international human rights or regional human rights treaties, to say that, the state has an obligation to respect, promote, and ensure these rights, that climate change is impacting those rights. And so there is responsibility and the state has to be held accountable, or the private actor has to be held accountable, and remedies can be sought because, that the state has breached its obligations. And so the question there, I think the most important question that you can immediately think of is, what are climate rights? What are climate rights as set out in the Constitution that you can actually claim? What are climate rights as set out in treaties that your country has ratified? And how can we enforce those rights in a domestic court? I think that's a super interesting question, and it is a question that is now before regional and international courts in requests for advisory opinions for the courts to elucidate, what are the human rights principles that govern this issue of the climate crisis, and what are the nature of state obligations under international human rights law? I think that's a very interesting question. And when we get to some of the cases, you will see that so far, as recently as just now, courts are coming with some very interesting answers that I think will change the trajectory of how civil society, individuals, vulnerable groups can leverage human rights law to tackle the climate crisis. Other categories of cases, some seek, domestic enforcement of international climate commitments as set out in the Paris Agreement. For example, this third one is very interesting for the Caribbean context. Some cases want to look at just keeping fossil fuels in the ground, keeping carbon sinks in the ground. And I say that's interesting because I immediately think of Guyana, where there is now a oil and gas industry, an expanding oil and gas industry. And so we have expansion of fossil fuel extraction at a time when there is scientific consensus that dominant modes of extractivism and the fossil fuels industry is fueling the climate crisis. And there are calls for a moratorium and so on, and that there should be no new development. And so I'd be very interested to see how this category of climate litigation cases that seeks to keep fossil fuels and carbon sinks in the ground, like how are those cases evolving? And on the question of carbon sinks, Guyana, again, industries that are fueling deforestation, can those industries be challenged on climate grounds? Because, you're not enhancing adaptive capacity, you are increasing vulnerability by destroying the climate resilience that comes from these carbon sinks. Another category of case seeks corporate liability and responsibility. And again, this is extremely important because we know the dynamic of what happens in the Caribbean, which is that, we have corporate actors and, including transnational corporations that come in, carry out these unsustainable development projects that are given the green light by governments. And so while we want to hold governments accountable, we also need to find a way to hold these companies accountable. And this question of corporate accountability is one of, I think, the central issues that international human rights law and domestic constitutional law will have to address, because we know that transnational corporations are the new sovereigns in that they have more resources and more power and more influence than even some countries. And so existing within this imaginary of only like state obligations and that's all that counts is not going to address the most challenging aspects of the climate crisis and other human rights abuses. I think the key will be how are we able to hold corporate actors accountable effectively. And then other climate cases have to do with climate disclosures and greenwashing. And so I don't know if you heard some of the stories about how oil companies try to mislead the public in terms of, their contributions to the climate crisis and so on. And so some cases try to challenge that. And then the last one is failure to adapt and the impacts of adaptation. And so because I'm a human rights lawyer, I want to focus a little bit on this issue of climate rights, the first category of cases, looking at climate rights and climate litigation and what this could mean for a place like the Caribbean. So what is the argument in, rights-based climate litigation? What is it that they're seeking to achieve? Or what is it that they're saying? And, we can't take this for granted, by the way, because this idea that the climate crisis is a relatively new idea. This is something that is just being developed, as hard as that is to believe. I'm sorry, my screen is freezing.
That's okay. It's fine. We
Yes.
just missed a very small bit of what you said a few seconds ago. Maybe you can repeat.
Sure. Yes. I was saying, what is the argument that rights-based climate litigation is putting forward? And that argument is that, climate rights emerge from existing constitutional and fundamental rights under domestic law. And I was saying that, we can't take this argument for granted because this idea of the interlinkages between, the climate crisis and human rights, it's something that is relatively new. And even now, as I speak, courts, as I said, are trying to understand what exactly are the links between the climate crisis and human rights. And you can appreciate the importance of that question because, as I said, once you use the language of human rights, you are using the language of accountability. Because under constitutional law, states cannot do anything to abrogate or breach constitutional rights. And under international human rights law, it's the same thing. And so if you say that the climate crisis is impacting human rights, it unleashes a whole range of remedies and actions that can be taken to not only to try to prevent harmful activities from even occurring, meaning that before a project even starts, you just shut it down because on human rights grounds. But you can also get remedies in terms of accountability, compensation, guarantees of non-repetition, and so on. And so this argument about the interlinkages between human rights and the climate crisis has a lot of potential in terms of bringing climate justice to the region. I think it will depend on how arguments are framed, how innovative people can be in the framing of their arguments, and then, of course, how willing courts are to seriously engage with what we are trying to say about the climate crisis, which is that the level of threat is existential, and courts must be engaged with the issue in terms of bringing remedies to vulnerable populations. And so, if we talk about climate rights on a constitutional or even international law, the question is then, what exactly are state obligations under human rights law? Because it's not like we have a constitution in Jamaica that says, and then in terms of climate change, here is what the state's supposed to do. I mean, climate change doesn't appear anywhere in our constitution. The right to a healthy environment doesn't even appear in the core UN treaties like the International Covenant on Civil and Political Rights. It doesn't even appear in the American Convention. And so when we talk about what are the state obligations under human rights law, we are engaged in an intellectual exercise that is extremely important, but also very difficult. But, reviewing what human rights bodies have said thus far on what those state obligations are, and those obligations would arise from an interpretation of authoritative binding documents, including international human rights treaties ratified by states. I just wanted to, this is by no means the full list of obligations, but I just wanted to pick out things that we could hold on to and take to a court, what are the specific things? And some of those specific things are mitigate climate change and prevent its negative human rights impacts, reduce greenhouse gas emissions, take steps to adapt to climate change, and then this concept of international cooperation, which is, because the climate crisis is a global crisis with transboundary effects, you must have a process of international cooperation, including things like the transfer of technology and assistance to developing countries to address the climate crisis. And so if these are some of the state obligations that human rights bodies say exist under human rights law, then maybe we can go to court and try to enforce these obligations. And so I just kind of did this chart of, rights-based litigation, whether under the Constitution and international human rights treaties, or, some arguments want to refer to the reference to human rights in the Paris Agreement, which is, a little tiny bit, but that tiny bit is important. And when we're talking about human rights law, whether in the Constitution or under international treaties, we're talking about at least 3 different types of obligations. We're talking about substantive obligations, meaning obligations to respect, protect, and ensure specific concrete rights. And what you see in this square to the left are rights that, have been adjudicated and found to be linked to the impacts of climate change. But in addition to the substantive rights, like impacts on the right to life, for example, if there's loss of life because of a catastrophic hurricane, and so on. In addition to those substantive rights, we also have procedural rights, and that means, the right to, it's all about environmental democracy. It's about the right to participate in development decision-making processes. It's about the right to access climate information, And it's about the right to access a remedy in cases of climate-related harms, because these rights will mean nothing, the substantive rights will mean nothing if you can't access a remedy, in cases of harm. And then the third bucket of obligations relate to like vulnerable groups, because under the human rights framework, this issue of discrimination or non-discrimination implies an obligation to take proactive measures in the case of vulnerable groups who are, either historically disadvantaged or are experiencing intersecting forms of subordination within society, whether on the grounds of race, gender, and so on. And so, we have specific obligations under human rights law, for example, for women, Indigenous and tribal people, for children, and so on. And then, as I said, the Paris Agreement calls for parties to respect, promote, and consider their obligations on human rights, including aspects of gender equality. But I always encourage you to look at the language that is used sometimes in treaties to see how strong that language is and what it's trying to achieve. Some language is extremely concrete, like states must not do this, or that, and then other languages, make your best efforts to, try to improve, language that isn't really concrete. But as I said, any little thing is important, but I always interrogate these things. So what does this mean for climate litigation? Now, there are so many climate litigation cases right now, and I just want to show you how human rights law is being used in some cases to spark ideas about the relevance of the Caribbean. And the cases I kind of pulled out are cases that resonated with me as a human rights lawyer based on how I see climate justice in the Caribbean, or how I see climate impacts in the Caribbean. And so one important case was this 2022 case before the Human Rights Committee. And this is a landmark case because it had to do with islanders, Torres Strait Island, indigenous Torres Strait Islanders, who argued that, their rights were being impacted because of the inaction of the Australian government in terms of its climate change obligations. And the UN Human Rights Committee found that, one, the Australian government was violating its human rights obligations to these indigenous Torres Strait Islanders because of what it was failing to do. So it's not even like the government did something concretely and that violated their rights. They're saying, actually, it's what you failed to do, which I think is so powerful. So it's climate change inaction. And the Human Rights Committee found that Australia's failure to adequately protect the islanders against the adverse impacts of climate change violated their rights to culture and constituted arbitrary interferences with their private life, family, and home. Which again, I think is significant because something like culture, this is a court, this is not a court, it's the UN Human Rights Committee, which is the adjudicatory body that monitors the International Covenant on Civil and Political Rights, which is one of the main human rights treaties, widely ratified. Something like culture, the Human Rights Committee is saying that this is interfering with their very culture, which I found significant. And this is the first time a UN body found that a country violated its international human rights law through inadequate climate policy. And as I said, the first time that Indigenous people's right to culture was found to be at risk from climate impacts. And I find that significant because we know that, the Caribbean is home to Indigenous peoples, and their culture is under threat by climate change. And so, this is something to think about. Even if the government isn't doing something actively to harm their rights, could the government be held accountable, or a government be held accountable for climate change inaction?
Malene, I'm so sorry to interrupt, but we are a little over time now with your presentation. Is it possible for you to wrap up in a couple of minutes, please?
Absolutely, yes. And thank you for the time check. Well, these are just other cases about failing to adequately mitigate the impacts of climate change, impacts on the right to a healthy environment, and so on. But what I want to say about these cases in terms of the Caribbean is, what are the challenges and opportunities for the Caribbean? And just to summarize in 1 minute, I would say that, first of all, it depends on what's in the Constitution. As I said, only 2 states in the Caribbean recognize the right to a healthy environment, which means that lawyers have to find innovative ways to bring climate litigation cases. The second thing is science. How do we prove that an actor, whether state or non-state, is contributing to the climate crisis and causing climate impacts that are violating human rights? Do we have the science and the scientific expertise in the Caribbean to leverage these cases? And the third thing is costs and length of litigation. How many communities have the financial capacity to present litigation and to see it through over years and years? And then the final thing I will say is the harassment of environmental rights defenders who take a critical stance against unsustainable development projects. And that's a critical issue because it impedes their ability to challenge unsustainable development projects. And so with that, thank you very much. I hope that this was insightful for you, and I'm happy to answer any further questions. Thanks.